February 7th, 2019, that was our initial
I
appeal.
don't see that.
That didn't come to us.
Okay, well, I only have one copy with me. Certainly, we submitted the requisite number. That was our initial appeal. That actually sets forth our...
But if it didn't come before our board, we wouldn't get a copy.
So it was sent to the board. It was my understanding that it was before the board.
But if it wasn't opened up as a public hearing, we wouldn't receive it.
So we are the applicant. We received a notice of violation.
Right, but
Correct.
you said there was a previous, this is a previous...
No, this is our first appearance.
Right, so when was this?
But you said
What is
there
it,
was
Let me start from the beginning. January 10th, 2019, we received a notice of violation from the
Right.
building
Yeah.
department.
Right.
On February 7th, 2019, we appealed that notice of violation to this board by submission from my office. That has with it several exhibits, one of them being our application, our notice of violation, and some pictures. It also sets forth our legal arguments for the granting of the one requested area variance.
So it's the tabbed exhibit, it's the tabbed section.
Yeah, we got that.
That we have February
So
6th, it's
you should have
dated.
two tabbed
Three,
exhibits.
it's Exhibit A, B, and C.
Correct. There's two submissions that have exhibits A, B, and C.
Right.
This is the one I'm talking about now. It has some markings on it.
Right, we have that we
This
have,
is-
I believe.
Nope, that's our supplemental submission. This is our
Oh,
actually.
this we do not get.
We don't
Mr.
have
Gottlieb,
that.
a
We
copy
have
of-
all the exhibits, but we do
We
not.
do not have that one.
Mr. Gottlieb, that went to Mr. Thomasberger.
So-
His letter to you dated the 25th of February says, "I received your letter dated February 7th, 2019."
Right, it did.
So
It didn't
this
come to
is-
the board, it came to Mr.
So-
Thomasberger.
Just for the record, so I can clarify and I'll bring it up, it's addressed to the ZBA. We submitted the requisite numbers of copies. It is our appeal, even if it did go to Mr. Thomasberger, the village law requires that it be forwarded to the ZBA upon appeal of the notice of violation.
Is there any difference between that and your letter from February 20th?
How do we enter
Yes,
this into the
substantial.
record?
And actually, our letter from February 25th references this
It's-
February 7th letter.
No, it didn't come to us. Do we have to,
No.
February 7th?
No, that's the 25th.
I got
That one, we
25th
have the
and I got-
25th, but not the February 7th.
March 7th.
We're not going to have
That
time to
was-
look at the February 7th one, but we'll address what's in the February 25th and March 7th and January 10th.
Certainly, I don't know where the error was. We submitted, I believe, 15 copies of the February 7th letter. I do not know how it did not get before the board. However, it is vital to your decision-making because it runs through the legal arguments that we set forth for the area variance.
Is it different than the,
Yes.
Yes, substantial.
oh, it is?
Then, you know what,
Do you
Karen,
want
I
to
think we're
postpone this till next month,
We're going to have
then?
to wait because
Because we won't have
Well, let
time
me-
to look at this.
Let me just suggest a few things since I did travel from Saratoga.
I agree.
Let me lay this out because this is a confusing application, so we can begin the process this evening and carry it over. You will notice we have 3 submissions before your board. We will make sure that you get to the February 7th and we'll find out what happened there. First, the notice of violation, which is, I believe, Exhibit B
We
to
have that.
February 7th
No, we have
submission.
January 10th. We have the January 10th one, I believe.
January 10th one.
Yeah.
Okay, so if you look at violation number 1 discusses a alleged violation of section 146-5A, which is related to fence height. Currently, that is the only area variance we seek. The fence starts near the front of the property, and it is zoning compliant for approximately 200 feet, and it's only 4 feet high. It is only towards near the front of the building where it goes up to 6 feet. So our area variance is only for the 48 inches of height that go from the beginning of the building to the rear of the property.
However, it's also the composition.
I promise that I will get to a lot of this
Okay,
here
all right.
tonight.
Thank you.
So the factors that I set forth in the February 7th letter, which you have not received, demonstrate that the benefit to the applicant greatly outweighs any detriment to the community for the following reasons. And I go through the balancing test. There is no blockage of any visibility for any drivers along Seven Springs Road because, as I mentioned, the fence near Seven Springs Road is zoning compliant. It's 4 feet there. It's only 6 feet as you near the
From the
actual
front corner of the
residence.
house to the rear, yes.
Correct.
Isn't it like solid though? Isn't it like 100%?
No, it is not 100%, and I will get to that.
But it's also not less than
at the
50%.
next, So the reason it is 6 feet in height is because there is a ditch. So Seven Springs Road kind of goes down gradient like this. So as the grading occurred for the residential property, which we obtained a building permit for, there's a ditch here, and it was a little bit exacerbated. So the 6 feet in height fence there is to prevent children who reside at the property and deter them from going to the neighboring property and getting stuck in that ditch. We have no objections from the one impacted neighbor who is, the top of my head, west, east, south, but on the other side of the fence. And we can discuss this once you have a better chance to review that February 7th letter. It's all laid out there. The second alleged violation in the notice of violation is on 146-6. We ask that we appeal that allegation, and we ask the ZBA reverse that and that allegation be withdrawn. 146-6 says that a fence can be no less than 6 inches from the property line. We submitted a survey on the February 25th submission that shows that that fence is about 5 feet from the property line.
I couldn't find the fence on the survey. All I found was a fence post.
So the fence posts would be
Attached to the,
attached to the fence.
Right, which,
So,
this is the fence post I found right here.
so it's actually the fence that's at issue is on this side of the property. So see each post is the rectangles there.
Oh, these are, okay.
So
There was
those
no
are the fence
key.
posts. No problem. And so the fence then goes to here, it's 6 feet, and then starting here, it goes to 4 feet to about right there.
Gotcha.
So I think there was a bit of confusion from the building official as to code citations. We do not understand why that violation is in the notice of violation, since the fence is about 5 feet away. So our appeal is that the ZBA reverse that allegation. Certainly, if the board feels otherwise or needs additional information, we would request the opportunity to apply for a variance for that differential. But as I said, that fence is about 5 feet off the property line. Now, related to fence composition, the notice of violation says nothing about any violations related to fence composition. Fence composition is in Village Code 146-7A, which you'll notice is not one of the violations that's stated in the notice of violation. So we ask that any enforcement related to 146-7A be prohibited, considering we don't have an active violation in front of us. Notwithstanding, if you look at Exhibit B from the February 25th submission, should be a bunch of pictures. If you look at the last picture there, this landscaping screening is put in about less than every other fence slot. Therefore, in this area, it is less than 50% solid.
Not from the street.
Say that again?
It's not from the street. You can very barely see some light through it, but it's not less than 50% solid. Plus, our code
So-
doesn't allow fabric or vinyl or that, that kind of stuff to be part of a fence.
That type of landscaping fabric, it's my understanding, and I would have to be pointed in the direction where it is a violation. And right now, that's not a violation before the board. What it is, it's the 50% opacity, which is this issue that's brought up, but it's not in the NOV, right? So we can't I can't appeal something that's not in a notice of violation. So we requested that the building official take a closer look at that. And if he does have to amend the notice of violation, that he should do so. And it would be our argument that it is less than 50% clear because that landscaping is put in more than every other site.
Right,
We
but
can
it's got little
certainly-
spiky things, so they all come together and makes it appear solid.
So
And
that
that's-
while they might appear solid, if that solid fabric is accounting for less than 50% of that fence, it is compliant with the village code, and that's what we would be appealing.
May I?
Yes,
I went and looked,
So,
because
yeah,
we've gone
I-
around
I did
this
also.
once before. I went to a fence place and I looked at actual solid fences. All right, now, it has to be less than 50%. I did go up and I did look at the fence on Mr. Brock's property, and basically, he's got one filled and one open, and one filled and one open. If you put the whole thing together, it's 50% full and 50% empty, so it's more than 50%.
it's solid, yeah.
To give you a different example, because like I said, I needed to get this clear in my mind. If you had a picket fence and the slats were 2 inches wide, and then you had 2 inches between that slat and the next slat, and you did that all the way across, 50% is closed, 50% is open. If you went with a 1.5 inch slat and a 2 inch space all the way across,
Would be
then
less
you
than-
have less than 50%. And he's kind of in the 50-50 category. I mean, you know, I didn't measure the whole thing out and do the arithmetic, but it kind of flies against what the code is trying to achieve. And if I may, on a 6-foot fence, it's only supposed to be a 4-foot fence by our code on the side.
Sides, yeah.
Once
Yeah,
it
and
gets-
that's what the variance was
yeah, and
requesting.
once it gets past the back corner of the house, the back line of the house, it has to go to 4 feet. So that whole thing, according to the violation, correct me if I'm wrong, is
No,
not in compliance.
From the front
we might
corner
need the
to the
building
rear.
inspector to make a determination on that point, because it is my understanding that a front and side yard fence is supposed to be 4 feet.
Correct.
We are requesting the additional 2 feet in that area. A
Yeah, but
front
that's a
yard
variance.
is,
That has, according to what he said, as it stands right now, you got a 6-foot fence where it's supposed to be a 4-foot fence.
That is-
And it's
there is-
not in compliance.
there's no argument there, but what you're saying is that once we pass the rear of the house towards the backyard, we then have to go back down to 4?
No.
No.
Coming forward from the back corner of the house, it has to be 4 feet.
Sure,
The
and
whole side of the house, if you will.
I am getting to that point as well, because if you look at the definition, yeah, sure. I just have to finish up a few things once Mr. Brock is done.
Karen, excuse me, this email that you got from Gary,
Right.
it
He's-
addresses what the gentleman says, that he says he is sticking with his original notice of violation, and he speaks to the solidness.
Right, but we only
But the gentleman
received
said that in
this
in
violation.
document, there are no violations for solid.
No, it's,
So I don't get Gary's,
no, that was why I emailed him. The only violation, notice of violation we have is the one from January 10th. And I read your February 25th exhibits, you know, the narrative as well as the diagrams and the survey and whatever. And I emailed Mr. Thomas Berger and said to him, well, what's going on? You know, do you need to renotice this? Do you need to, you know, go back to another? And he just said he stands by his original violation. Is this the original violation?
That is the original.
because it has his
We
signature.
sought to gain
Right,
additional
but-
information as to this opacity issue. None was provided. We wanted to preserve Mr. Brock's right by appealing this because we knew that it was around. But if it is truly a violation, the notice of violation should be amended so we can properly appeal it.
So do you want us this evening to address the, what is in the violation, the height
So,
and location, meaning, I guess, side yard, front yard? You know, in other words, you can't have a 4-foot fence, a 6-foot fence in a side yard. Is that what you wished us to address tonight?
that, and I brought the composition issue to the board's attention because if you could go back to the building inspector or make a determination here this evening that there is no violation of record related to the opacity of the fence, that would be the determination that we would seek. And
But
additionally,
you do exceed the permitted height.
Right, he's not arguing that. He's not arguing that. What he's arguing is the
But I know,
50,
but
less than
It's in
50%
the
solid.
violation order. You
So
can't
we can
just-
address, this evening, we can address the height issue,
well,
but you wish to have a
Well-
new or amended notice of violation issued before we address the composition?
No, address the height issue. My name is Sigmund Brach, and when Gary said that I need to take out a slot from the green, and I did that. I did take out a slot, and we cut down the gate. But instead, when you have the house comes out, there's an entrance in the front. So it's not in the point even of the house. It's a little bit where the steps come out, the front of the house. So we did cut down quite a lot. And I also would like you to understand, it's not on the front, because I keep on talking about the front of the property. There's no fence on the front, as Mr. David was there.
Right,
And
but
and
it's considered, even though it's along the side of the property,
No, that-
because it's in
It's-
forward of the house, it's considered the front.
Yeah, but the side, this is like 200 feet inside. And the reason of that law was made, it shouldn't obstruct the traffic. And if the ZBA will deny that, my choice on I will go to court and fight it. That's an illegal law, and I fought the village of Woodbury and on the water tower when I wanted to take out water, and I won it in court. A village cannot make a law that has no meaning for it. It could be challenged just because a board of 5 people, a mayor with 4 trustees, decide to make any law they want. There need to be basis. The law is based of obstruction. 200 feet, there's no traffic obstruction where the fence starts.
I understand
6
what
feet.
you're saying.
So you are welcome to deny it, and we'll be in court. I don't want to come back. If you just rule on the height and don't worry about anything else.
No, I'm not ruling on the height tonight. I don't want to.
So I ain't gonna do nothing. So what, you could decide, because I'm not gonna come back for a fence 10 times and play with me games just because I'm a Hasidic Jew. I'm not obstructing any traffic. You were there, I saw you in the camera, you drove up and you looked at the fence. Did you have any obstruction of the, where it starts 6
I've
feet?
heard enough.
You were there, and you'll be a witness if you had any obstruction. There was no obstruction there.
Just looking
Come
at
on,
the
Karen,
fence.
we don't
No.
have to put up
You
with
were
that.
there, so what is the law for? Tell me what the law
Miss-
says obstruction.
Not my-
Mr. Brock, when we,
Just a rule on the fence, that's it.
Hopefully, Mr. Gottlieb does something with him because
I don't want to talk about anything else.
the notice,
Because I can take down the slats, all this thing is nonsense. Just rule on the side.
So the last point, just to preserve Mr. Brock's legal rights, are that the notice of violation, we would have the ZBA request that it cannot be enforced. If you look at the notice of violation, the enforcement provision noted is a zoning code provision. It says 31050. The fence law is not in the zoning code. The fence law is in the village code. Enforcement, if the village wanted to enforce against this, which it can't under this NOV, should be under 146-8, which only warrants removal of a fence if the fence does not, and I quote, interfere with the adequate visibility for operators of motor vehicles, which this clearly does not, because for 200 feet from the road, it is zoning compliant.
Council, we're going to need some guidance on this. We have always ruled on fences, front yard, side yard, backyard, 50%, less than 50%, et cetera, et cetera. Some been denied, some been accepted. What the intention of the law was, I wasn't around when that was made.
I was only pointing out that where it says in the bottom of the NOV how it is enforced, the citation is to a citation of the zoning code. The fence law is in chapter 146, which is not the zoning code. So the building official is seeking to enforce these violations with an enforcement section that is not applicable to the fence law.
so you're using a technicality.
Well, it's in the village's law.
Well, I'm not gonna vote on this to begin with because I'm annoyed at his.
You can do whatever you want, it's your choice. You can make the next move. You gotta deny it, you gotta prove it.
Rob, any comment
I don't
on the,
have to do
on the,
nothing.
on the legality?
I'm sorry, what, Gary?
I was asking if-
Mr. Brock, hold on
if-
just a
if-
minute, please.
If Rob had any comment on Mr. Gottlieb's issue of misapplication of the statute.
Well, I have concern that this board is being asked to rule upon the sufficiency of a violation notice issued by the building inspector. If there's going to be an enforcement action by the building inspector on that, that's something that Mr. Gottlieb would take in front of the local justice with respect to that issue. I don't know that it's something that this board can rule upon.
Well, actually,
Is ours-
the village law, New York village law allows us to appeal a notice of violation to the ZBA, which stays all enforcement in local courts.
I don't dispute what you're saying, but that's not what you're asking of this board. You're asking this board to rule on the sufficiency of an accusatory instrument, ostensibly. I'm not prepared to answer the question that's being asked of me tonight as to whether or not that's appropriate.
Understood.
As part of that, I believe your argument with respect to that is made in an application that for some unexplained reason the board doesn't have. And so we don't have the benefit of your argument with respect to that. And certainly the board should not be expected to rule on that part of your application tonight, nor would I comment on with respect to whether it's not appropriate or not. What I have heard you say, and I believe the board is willing to entertain tonight, are the three issues that you mentioned. The variance for the fence, the location of the fence, and the composition or the opacity of the fence. If you want the board to proceed on those questions, I believe the board is prepared to hear your testimony with respect to it. I don't think you want to bifurcate this proceeding because you'd have to come back on the sufficiency question, get a determination, come back again on a variance. I think you ought to combine them and have all of those issues heard at once. But your client is now telling us that perhaps he wants to withdraw those two of those three things that are before the board this evening. I don't know if you're prepared to do that on his behalf or not. Maybe you want a quick recess to discuss it with him. But if you're going to withdraw the location of the fence issue and the opacity issue, then the board doesn't need to go down that path.
So the opacity issue, the February 7th letter with exhibits, which we properly submitted in accordance with all village standards. I don't know why it's not before this board. I don't know why this process with my applicant has been any different from other processes. That being said, I could run through those area variance standards if I could just take the.
I wanna see it.
Hold on, all stop. First of all, there's a difference between the way it's written up and the violation order, okay, with these two documents right here. I think
Right,
it needs
and
to
we
be
had-
clarified by Gary, the code enforcement officer, okay, as to what needs to be done or what he needs to do, if anything.
Which is what
with this.
why I sent that original email.
Uh-huh.
But
Yes.
it was not clarified, but it was too late to actually do anything at that point.
So, as much as or we regret, speaking for myself as well, bringing you here tonight, and it seems like we need to do a little bit of clarification before we can entertain anything. And if I may, Karen, just one point. We never got any answers to the balancing questions. I mean, it says, see the cover letter. The cover letter, you know, when people have done that in the past, they do have a section of the cover letter that does the 5 questions.
Well,
It gives answers. Wait a minute.
I could quickly
Wait a
answer
minute.
that.
Wait. Okay. You know, it isn't our place to go through and hunt out the answers for this and hope that we're right, sir. I mean, if you're going to do the variance, then you have to address the questions 1 through 5 with your answers to each
The
question.
February 7th submission will answer all of your questions. That is the cover letter that the board, for some reason, is
Then why
missing.
don't we wait? Why don't we wait till next
All
month?
right, maybe
and
we
then
should
get the
table this
February
until
7th.
next
Get the
month.
February 7th, we get the information.
Is that what we need to
Yes, we
address the?
clarify this.
I just
I
hope
wanna ask
the
Mr. Gottlieb this.
board can appreciate my client's frustration as
I
we
just
now
want
have a
this one
submission
thing.
that's
I'm
missing.
gonna submit everything and let the board make. It costs me $5,000 every time it comes down to
Please speak into the
Saratoga.
microphone.
So.
Mr. Brock, could you use the microphone?
I'm sorry.
Sorry, please,
5,000?
thank you. Why would it cost you $5,000 every time you come?
Because he has to prepare everything else. It's,
Oh,
you know, I'll have him submit everything and the board should decide on the height, no problem. So I
It's not
could,
our fault we didn't get the information.
so we don't, but we don't have to attend. You
Don't
could
kill
have a
the
public
messenger.
hearing, and you could make determination. He'll represent, at least you understand what the argument is, where the law applies, and where the house is, where it starts is a few feet before the house, just like where the entrance comes out, because the entrance is in the front of the house. I mean, Mr., I don't know what his name is, he saw it. It's a beautiful property, nice landscaping. It's one of the gorgeous houses that's on that whole area. So it's not, and it pays almost $35,000 in taxes. And when it's not obstructing any traffic whatsoever, it's so far in the house that you call it a side yard. I think there gotta be a little determination what a side yard, how deep a side yard means. A front yard, I understand, it's the whole front. But a side yard, this is way, way in there. And
It all really
you're
basically
welcome
has to do
go
with the
down there and
location.
look at it, and you'll understand what I'm talking about.
I was there also, not with him, but separately.
But it's way in where that starts. That house is over 200 feet from the road. So there's no obstruction of anything.
I think what we'll do is
So
we
we're
will,
gonna submit everything, no problem, and you make determination, and whatever the vote is,
We-
then have to go next.
Just a
Yes.
quick question.
Sure.
Yes, sure.
On the distance of the thing from the line, the line's an invisible thing, but when I was looking at the part of the fence that exists closest to the road, this Evans Springs Road.
Right, the part that
There
isn't
was a
co-
fence marker, or a fence post, and it would spray red right by the road, and it looked to be just outside of that downhill part of the 4 foot.
No, we would think to make a gate to close it, but we're not doing it. I think
Also,
you're
up towards
thinking
the
that.
top, there was the sort of like benchmark markers that they use when they're surveying. They tie off a piece of
like that plastic,
plastic.
yeah.
And that was uphill towards the house, and then they were spread out. Is that any kind of marking as to where the boundary line is? I guess is where I'm going with this.
Not at all.
The property line?
We,
The survey, that's exactly where the property.
Well, a survey's a nice thing, but that's a piece of paper that I can look at. Is there any actual marker posts that a surveyor put in so that we know,
He wants to see a stake of the property line.
oh, you want to see a stake? A stake could be put,
well,
that's not there.
it needs to go with this, there has to be a stake where your property ends down by the road someplace.
You know what have mistakes, like how banks and banks it down. I'm sure beginning on it was staked out. I mean, I could have a survey put down stakes again. That's not an issue. We could put down little flags. I understand the survey company, there was not a
Joe,
surveyor.
they have submitted a survey with the fence, which is definitely more than 6 inches, so we can't say, Mr. Brock, you need to show us stakes in the
Okay,
ground.
right.
We
I
need
was
to
looking
accept
for
the
the same
survey
thing.
as the proof. I mean,
Do they go all the way down? No, I looked at it. Do they go all the way down? Because I didn't see something that clearly caught my eye as being,
right, however, the fence that's from the road to where it's solid is not solid, and it's 4 foot, so that is not even in the application. It's not part of the application. In other words, the fence from on the left side of the house you're talking about, right? That-
yeah, going uphill.
Okay, right. From the road to where it starts with that landscaping stuff, it's just a chain link fence,
Correct.
And it's 4 feet.
and it's 4 foot high. So it's,
I'm talking about the 6 inches from the boundary line.
right, but he has submitted a survey that shows that it's definitely more than 6 inches
All right.
from the boundary
I'm
line.
just saying, I need to have that shown to me because I was looking at the thing and I couldn't pick up where the markers were. You asked about it as well at the beginning.
I couldn't figure out where on the survey it was.
All right, you show me.
I will.
If
Yeah.
I'm wrong, I
Yeah.
apologize. I'm just trying to get one part of the
Yeah,
puzzle.
I couldn't find the fence on the survey, because there was no key.
And if you were nice, you would put Mr. Gottlieb earlier on the agenda so that he could get back to before midnight.
That is true. I'm sorry.
I'm at home, I'm in no hurry.
Okay,
I think maybe, do you want to entertain the height this evening, or do you want to wait until
I wanna-
everything
I
is?
want-
Start
to
with
see
Gary
everything.
And get the February 7th letter and then we'll
And
come
address
back
everything? And Mr. Brock and Mr. Gottlieb, do you want Mr. Thomas Berger to either reissue or amend the violation to include the things that are not included in the January 10th?
Certainly, we have asked for
I
the
s-
same clarification you have.
Right.
Without response. Certainly, we don't want him to reissue any notices of violation, but maybe if he could explain himself in some manner. Right now, the opacity issue is a non-issue. We have no violation on record with the village that we are in violation.
Can you reiterate those questions in a letter to Gary and then CC us so that we are,
I can, but I have done that repeatedly, and for some reason, it's not getting before the board. Certainly, I've emailed, I've mailed.
how can Mr. Gottlieb make sure that the documents get to us, Karen?
Gotta call Maria.
I don't know.
Maria's the one with all the documents. She's the one.
So, we
Well,
we certainly can do that.
The letter that from February 25th from Mr. Thomas Berger to you, Mr. Gottlieb, does mention the 50% solid. It mentions the notice of violation from January 10th. It talks about the height. And basically, those are the two things, the height and the
Which is why
composition.
there's confusion, because the instrument that.
The notice of violation doesn't address,
Not mention opacity.
right, I agree,
It mentions location and height.
right. So what is it?
Sorry, can we talk to them?
Oh, sorry. So what is it exactly that you want us to do
Get rid of all
So-
violations.
so that next month we can totally address every
So-
issue and nobody has to reappear or
We
do
will
whatever?
resubmit our February 7th application. What we are requesting at this time.
That's what I want to know.
Is an area variance related to the height. The February 7th application goes through the area variance standards, makes our legal arguments, which we will be more than satisfied with. Secondly, we appealed the notice of violation related to the 6 inches from the property line. As you can see, the fence is more than 6 inches, as you've even concluded yourself. So we ask that the ZBA overturn that allegation in the notice of violation. Thirdly, we only brought up the opacity issue to preserve Mr. Brock's legal rights. Currently, there is no criminal instrument that properly alleges that he has an opacity issue. If that is the case, which we do not believe it is, we would ask for additional information from the building inspector as to how he made that determination so we can properly appeal it to this board.
Or address it?
Correct.
Right.
Fourth, we have brought up, and the board's attorney has brought up a good issue, and we will look at it. The notice of violation does not cite the proper enforcement powers of the village in this notice of violation. While be it a technicality, maybe, any property owner within the village deserves the right to have a properly prepared instrument giving him all the facts of a violation. So we appeal that as well. Those are the 4 issues that we've outlined in all of our submissions.
All right.
Okay, do you guys want to table the height and wait until next
Yeah,
month to
let's-
do everything?
Let's do everything.
All at once? All right, and in the interim,
We'll do less
we will be in
confusion.
touch with Mr. Thomas Berger. Hopefully by the next meeting, we will have everything that's needed.
And we will
Someone-
submit proof to the extent I can that February 7th appeal document was properly submitted in accordance with all
Okay,
village
yeah, I
records.
think
because,
somehow it just got lost in the shuffle.
You
I
know,
don't know
just
what
for the
happened.
record, I will point out it is expensive for Mr. Brock to have keep coming back and
Yes,
back.
yes.
And that is a mistake that is unfortunately quite costly to the applicant.
Instead of winery and building, this is spend so much legal fees, you know?
Yes, no, I'm sorry for that.
No way to take their views.
I make a
Yeah.
motion, we carry this over to the May 8th meeting.
And keep the public hearing, yeah.
Keep the public hearing open.
Oh,
Oh.
hold on a minute. Are you here to speak to this application? No? Okay.
May I suggest one thing? Just for a point of clarity, there was the whether it be a typo or what in the notice document related to that provision of the code, I would suggest.
Oh, yes, yes, I saw that.
It be
Yeah,
renoticed.
The 9,
Our office is happy to draft the notice. Just let us know.
do I have a second to carry over the public hearing? All in favor? Aye. So we will carry this over until till the next meeting, May 8th, and hopefully we'll have all our information by then. Thank you so much.
I make a motion for adjournment.
Wait a minute. We have no building inspector's report, no public hearings. Do I have a motion for adjournment?
Motion for adjournment.
Second.
All in favor?
Aye.
Aye. Okay, meeting is adjourned.
I did.
Gary did.